Ibrahim Musana, alias Pressure 24/7, who is grappling with offences of hate speech and malicious information against President Yoweri Kaguta Museveni, Kabaka of Buganda, Speaker of Parliament Anita Among, among others, has again appeared at Buganda Road Magistrates Court to proceed with the case against him. In the last court sitting, the accused applied for bail by presenting two sureties, his sister Brenda Nambozo and a colleague Sembata Ibrahim, Friday morning before Magistrate Ronald Kaizi. In its response, prosecution led by Senior State Attorney Richard Birivumbuka objected to the bail application on grounds that the accused has no fixed place of abode and sureties were not fit as per court standards. This was also in regard to the investigations officer Mpamizo Agre's affidavit that was tendered into court.
Your Worship, today was the prosecutor's day to respond to the applicant's application for bail.
Yes.
Your Worship, we do appreciate that it is the accused's right to apply for bail.
Just a minute. Let me pull that. I do appreciate.
Yes, that is the applicant's right to apply for bail. One, the validity of the recommendation letter to the accused person or the applicant. And the recommendation letters, the recommendation letter for the applicant, on verification, it was found out never been a resident of that place. The chairperson LC1 confirmed that.
The resident
of the place which is in the
that's that zone. Eh?
Yes.
Of this paragraph what?
This is paragraph 7 of the affidavit. His annexure is D, is marked as D.
So the letter.
Connection between the chairperson's letter and a place where, from a hotel called Alexis. And the implication of that is that he does not have a fixed place of abode. Consider why court is granting or releasing him on bail. Extremely difficult for police to locate him and arrest him. In considering whether or not an accused person is eligible to be released on bail, the place of residence or fixed place of abode plays an important role because it speaks to the credibility of the accused person or the applicant and the possibility of rearresting him in case he absconds bail. Exhibits no credibility, then who are we to assume his worth? Failure to have a fixed place of abode makes him a flight risk. Makes him a flight risk. That the chances of him absconding bail in case he's released are so high. And in that respect, court cannot assume the risk. Your Worship, I will refer you to the case of Ebya Francis. The risk of releasing the applicant on bail. And this is exactly that is happening in this matter. We pray that this court that of releasing him on bail, since the trust in him is in question. Prosecution would have had nothing to say had the applicant proven that he has a fixed place of abode. Your Worship, I wish to submit that in respect to Sembata Moses, Ibrahim. Upon verification, it was found out that Sembata Ibrahim is no longer a resident. Is no longer a resident of the area which appears in his introduction letter.
The approved state?
Yes, Your Worship. I am,
Not paragraph 10?
no. I want to refer you first of all to paragraph 8, where we attached his introduction letter, which is in dispute, as annexure F. Then I want to refer you to paragraph 10 of the affidavit, in which the chairperson LC1 was categorically clear that the said surety is no longer a resident of that place.
That's the same of Muzana zone?
Yes. And that letter is marked as annexure G. I refer you to paragraph 10.
Annexure G.
Annexure G.
Yes, this is Muzana zone. Do letters look alike? Let me have a look at this one. This is on record. Yes, they look alike.
Yes.
You mean she can shift anytime?
Yes. And Your Worship will refer you to paragraph 10.
10?
Paragraph 10, yes. No, 9 of the affidavit. Your Worship, allow me to submit about those two sureties jointly. For a surety to be substantial or to be considered substantial, there are several considerations that court must look at. One of them, as I said earlier on, is having a fixed place of abode. Which does not exist in our instant case. The current residence of Sembatia is not known. Nambozo is a tenant who is temporal, that can shift anytime. And the applicant, much as is not a surety, cannot be placed anywhere. Now, the implication in respect to Ibrahim, the applicant, the surety, is that he lied to court, that he has a fixed place of abode. And those are all trust issues. Which was never the case. They were simply talking about I'm a businessman, business lady in places they couldn't even locate. No one can locate the businesses they were talking about. That is one loophole. Two, they have to show that by producing bank statements, a reality.
Communicate with your lawyers.
You are talking about the sureties, not the accused person. Your Worship, I would like to refer you.
He further cited that following the nature of the offense, the accused is safer in prison than outside, since he might be subjected to mob justice. However, this was objected to by the defense lawyers, saying that prosecution's intention is to keep the accused person in prison.
The only way the public interest can be protected is by keeping the applicant in custody until the matter is complete.
By keeping
the applicant in custody until the matter is complete. The applicant attacked very important persons in this country, that even his life is insecure. And actually being in custody is for his own benefit. being in custody is for his own benefit. In fact, if I were him, I wouldn't even mention the word application for bail. First of all, Your Worship, I have a copy of this ruling for court.
You are saying that he's safer in prison?
He's safer in prison, Your Worship. And Your Worship, it's not only speculative, but I would refer you to got hold of the applicant. He would be dissected into pieces. So he is safer in custody.
I would like to object to that.
After listening to both sides' submissions, Magistrate Ronald in his ruling dismissed Musana's bail application.
Officer, does the state order has enough evidence against the accused person, and that's why they will charge him in court, and therefore the accused person, pray that the court listed the accused person on very lenient terms, particularly on non-cash bail. They should not be right to apply for bail, which court has discretion to grant or not to grant in accordance with the law. I have carefully addressed my mind to paragraph 13 of the Constitution, Bail Guidance for Courts of Judicature, Practice Direction of 2022, particularly paragraph 13 on concession for grant of bail. The same paragraph states that the court shall consider the following in handling a bail application. 1. The gravity of the offense. B. The nature of the offense. C. The antecedents of the applicant insofar as they are known. D. The possibility of a substantial delay of the trial. E. The applicant's age, physical and mental conditions. F. The likelihood of the applicant to attend court. G. The stage of proceedings. H. The likelihood of whether the applicant has a fixed place of abode within Uganda or whether he or she is ordinary resident outside Uganda. L. Whether the applicant is sufficient sureties within Uganda to undertake that the applicant shall comply with the conditions of his or her bail, among others. I note that the residence of the applicant is not clear. The charge sheet has his residence as Gauka Mukono, and when the charges were read to him, he never denied this particular fact. The letter introducing him came from Church Zone in Najanankumbi, whose chairperson OC1 has since disowned the said accused person as case said that not a resident of the area. There is also another letter from Kakoli Nibudaka where they allege that he stayed with Maza during holidays. According to the police, he was arrested from a hotel in Ntinda where he had stayed for 2 months. In light of paragraph 13(1)k of the bail guidelines, I don't find the accused person to have a fixed place of abode. The evidence on record shows that he stays in Church Zone, Kauga in Mukono, Kakoli Nibudaka, and the hotel in Ntinda. Paragraph 15(1) of the bail guidelines sets out what court has to consider in finding surety substantial, and these include the age of the surety, work and residence address of the sureties, surety numbers of Brenda as a place of work and residence at Church Zone, and Marcia she is a tenant. She's also a sister of the accused person. In light of paragraph 15(1) A and E of the bail guides, I find her substantial. However, suite number to Mr. Sembatia Ibrahim Matia has no clear place of residence, as he was disowned by the area chairperson of the zone where he alleges to be staying. He has no clear relationship with the accused person. A mere sister is his friend. And in light of paragraph 15(1) B and E of the bail guidelines, I don't find Mr. Sembatia Ibrahim Matia a substantial surety to stand for the accused person. An applicant's place of abode and without substantial sureties cannot be released on bail. If court did so, it would assume a risk, as stated in the case of Francis Onebe versus Uganda, which was cited above. I'm not ready to assume this risk for the reasons stated above, and for those reasons, I do reject the bail application and further remand the accused the 26th of March 2024 when the case shall come up for mention.
With this, remanded the accused persons to Zilla Government Prison until 26th March 2024. After court, some people from Buganda Kingdom were pleased with the ruling.
Aba Buganda abaze mbungi mu kkooti olwaleero okuyimira ne Namulondo Banaffe bangi abavuddeyo ne bagezaako okuyisa olugaayu mu Ssaabasajja Kabaka. Ssaabasajja Kabaka omulembe guno yagukwasa abavubuka. Fejje eri ezibizi. Era njagala kukunga abavubuka bonna, Bankobaza Mbogo, BYC, Kabaka Munyango, banga bonna okubeera obulindala nga Namulondo erumbiddwa. Era tetugenda kukoowa. Tugenda kujjanga buli kaseera buli kanaku okulaba nga ekitiibwa kya Ssaabasajja Kabaka tukikuuma kidda waggulu. Bantu bangi abavunaana pressure, mulimu yavuma president, yavuma speaker, neffe tuli wano ku lwa Ssaabasajja Kabaka wa Buganda.
Mwebale nnyo, nze omwogezi w'abavubuka mu Bwakabaka Zimbeze Fania, nyongera okutuusa eddoboozi ly'abavubuka bonna mu Bwakabaka abatakkiririza mu kuvoola Namulondo era abavubuka bannannyini mulembe guno abaliwo olwaleero nga balaba nti ekitiibwa kya Ssaabasajja kikuumibwa bulungi nnyo ate ennono z'abajjajjaffe zikuumibwa bulungi era tezivoolwa. N'olwekyo tukubiriza abavubuka bonna okwongera okunyweza n'okulimira ku nsonga ssemasonga esooka ey'okukuuma Namulondo n'okulaba nti oyo yenna avoola Obwakabaka akwatibwako, era tukubiriza abavubuka bonna okukozesa obulungi emitimbagano gino okulaba nti emitimbagano gino ne tekinologi yono atuyamba kwekulaakulanya wabula si kunyooma na kuvuma na kuvoola bakulembeze baffe.
Prosecution alleges that between August 2023 and February 2024, in areas of Kampala district, while using a computer via his TikTok account, identified as Pressure 24/7, Musana shared information to demean and promote hostility against President Yoweri Kaguta Museveni, Kabaka Ronald Muwenda Mutebi, among others. In another development, the hearing of the offences of incitement to violence against Dr. Kizza Besigye and Samuel Lubega Mukako before Magistrate in Nancha at the same court has flopped. This followed the absence of the prosecution lawyer, who was occupied in another case. Magistrate Nancha adjourned the case to 19th April 2024 for further hearing.